last week, Senate President Godswill Akpabio and Senator Oshiomhole clashed barely 24 hours after the Senate amended its standing rules to restrict eligibility for presiding offices. Oshiomhole's confrontation was linked to the Senate's recent amendment of its standing rules, which introduced stricter eligibility requirements for leadership positions in the 11th Senate. The Senate had amended Orders 4 and 5 of its standing rules, tightening eligibility for presiding and principal offices. Another controversial rule, which mandated that senators-elect must take their oath of office before electing presiding officers on Inauguration Day, was rescinded after its earlier amendment. The decision followed a motion moved during plenary by the Senate leader, Akpabio Bamidele. Joining us now on the show to discuss the controversial House rules is Senator Oshiomhole, senator representing the Edo North Senatorial District. He will also discuss the Electoral Act as amended and allegations of over-concentration of power by the president on governors over National Assembly members. Good morning, Senator Oshiomhole, and thank you for joining us on the morning show.
Thank you very much, Dr. Ruben Agbati and your colleagues.
Well,
Senator, greet us now. Are we colleagues now? Senator Rufai is here. Ayo is here.
Good morning,
greet us, Senator. Is it because you are wearing a fine suit? Greet us, Senator.
Yes.
Anyway, Senator.
You know, Rufai, I am a tailor. I needed to teach you how to make latest suits. And for Ayo, I needed her to know that her brother is kicking.
Yeah, yes, you are.
For the Niger wife, she is there. Okay, I am here ready to see my old friends. You fight me every day. I watch you.
Yes,
and you do one-sided punching. And I'm like, okay, one day.
Standard.
One day we will see.
You're looking dapper.
You're looking dapper, we must say.
Okay, Senator. Now, we don't need to give
thank you very much. You know what?
We don't need to give any long summary. The subject is about the attempt by the Senate to change the standing rules with regard to eligibility and procedure for access to principal positions in that National Assembly. And, you know, we had the report of you standing up to the proposal by the Senate president. But at the end of the day, we heard that there was some accommodation, but it looks like the substantive issue still stands with regard to eligibility. What has been amended now is the procedure, yes or no. Who won, who lost on this issue, and what were your major concerns about equity, about, you know, legality and all of that?
All right, thank you very much. I think the issues are, for me, more straightforward. First, let me give you a background, and I ask you to confirm it with every senator in the 10th Assembly. My view is we must not rush in making laws. Every clause, every word must benefit from scrutiny. And so, rushing, pam, at the end of the day, we have made a couple of mistakes, couple of times, making laws that are in conflict with existing law that the 10th Assembly has made, or even more seriously, making laws that are in conflict with the Nigeria Constitution. And the only way to avoid those avoidable errors is to allow for proper debate. Anything you want to do, whether it is rule changing or law making, it is important that senators have the benefit of advanced copies. Read it, study it. That is what we are supposed to have, and we do have legislative assistants. So if you don't have enough time, you can commit it to your staff to look at it in the light of existing law or existing national constitution. But you bring important rules to the floor of the Senate without anyone having previous opportunity to look at it, and you discuss it there and then, and you pass it. Now, I have two issues on that day. The first is that I raise point of order under the rules of the Senate, because the Senate president was emphasizing that he has the power to interpret the rule. That is correct. But only after the point of order has been raised, he has the power to decide, and that is the interpretation, whether the content of the point of order, as written in the rules of the Senate, have any relationship with the matter at hand. In this case, I specifically raised under 70, after all the other arguments about the morality, the appropriateness of changing rules that are working. They say if it is not broken, you don't mend it. Now, those were rushed. Now, I asked for the floor to raise my right, which the presiding officer cannot deny. That is Order 70. What is in Order 70? Order 70 is the very same rule that Senator Abaribe raised when we were amending the Electoral Act. It says, basically, that once it is raised, the Senate president is obliged. It's not out of his discretion. He must divide the House. The benefit of that is that when you are dealing with very serious matters, the constituents needs to know who voted for what or who voted against what. But much more importantly, also to be sure that what has been decided is a reflection of the views of the majority. But it is very difficult when you say the nays and the ayes, the presiding officer will choose what he heard loudest. That is not appropriate for important lawmaking or important rule changing. So I raised that point of order and he declined to allow me to raise it. And I said, no, it is my right so to raise it, but it is his right. When I raise it, he will ask me under the rule to read it out. When I read it out, both the presiding officer and other distinguished senators will be able to make up their mind whether that point of order is relevant to the matter at hand. And nobody can question the fact that when you want to change a rule, it's literally not rule for ourselves now, rule for the future. For the incoming senators, we are trying to change the rules that brought us and make more rules for those who are coming. Why not allow the next Senate to make their rules? But anyway, that for me was a procedural issue. So when he refused to allow me to raise that rule, the point of order, the following day I attempted to raise it again while they were adopting the vote of proceedings. Now some people say by the rule, I saw a couple of comments that doesn't seem to understand the issue, that I should have allowed the vote of proceeding to be passed before raising point of order. They don't understand the rules. Now, once you have passed the votes of proceedings, then you can no longer question it. Now, I wanted to question the validity of the votes of proceedings because in my judgment, because the House was not divided, even when I asked for the floor, so to do, anything he did or anything that the Senate did without following that procedure, which we are obliged to follow. In my judgment, it's an act in futility. And that is why he tried to ask us to pass the vote of proceedings, whether they are a fair reflection or what was agreed. I wanted to challenge the legitimacy and the validity of those votes. That was why I raised the point of order before adopting the controversial amendment. And as you can see, there is no better evidence of the danger of rushing than the fact that the following day, that same day, the following day, the Senate has to go through the humiliation of revising itself that it has made laws or rules that are in conflict with the Nigerian Constitution. Why should we make that mistake in the first instance? I was also suspicious that day the Deputy Senate President had engagement in Kano, he was not around. The Senate leader also had engagement, he was not around. And I was suspicious why this change of rules will be made when these two senior principal officers of the Senate are not present. All of that raises that as to what was the intention. And let me also say this so that I can save your time. I watched your reaction to it, Ruben, and I believe Rufai too. You thought that these are elite issues. It's about who gets this, who doesn't get that in the next Senate. And I'm like, no, this is not a deep reflection before coming to that conclusion. Why? Because when African elites, particularly presiding presidents, in this case, President of the Senate, seeks to amend the Constitution to allow for another term, as we have seen in Cameroon, as we have seen in Uganda, as is already happening in this country that has been making progress, but I think Kigali is heading towards the same direction, where sitting president begin to tamper with the rules of tenure. That is how dictators emerge. And if it is their privilege, if it's an elite issue, whether or not a man should perpetrate himself or not, by the time they begin to do so, it is the proverbial grass that suffers.
But Senator,
when the key issue is
Senator,
stay put. So that's it.
Senator, no, one clarification.
Yes, sir.
You know Senator Adeniyi Adegbomire, SAN, who is chairman of the Judicial Committee, he issued a statement saying that what has changed now is the procedure. The point about how the initial decision contradicted Section 52 of the 1999 Constitution, which was, your main objection. And that now they have agreed that you don't have to take an oath before you can be eligible to vote. But the other issue about eligibility, Senator Adegbomire was saying stands, which is that you must have stayed in that parliament consecutively for 2 terms before you can be eligible to be appointed as a principal officer of the Senate. Is that clarification, is it correct?
Yeah, what SAN Adegbomire said is correct. And that is why I say the fight is not over. Because even the current Senate president, Godswill Akpabio, did 4 years. Subsequently, he lost election to the Senate and he became a minister. Now he came back this term and he became Senate president. If you add the first term plus the current one, he would not have done 8 years. Indeed, he's probably doing the 4, 5, 6, maybe he's approaching 7 years now. So if 8 years is a minimum requirement, he doesn't have the right to preside because he has not acquired the qualification.
Right.
If he got it in error, it has to be corrected. So that is why you don't make laws with people in mind. Number 2, there is another thing that Adegbomire did not amplify. And that is the word consecutively. If you say consecutively, it means the first tenure of the distinguished Senate President, Akpabio, in the 8th Senate will not count because he was not in the 9th Senate and therefore is not consecutive. Strictly speaking, by the interpretation of the rules that have been made, he has only done, he's approaching 3 years as a senator for the purpose of ranking.
Okay.
And I hold the view that this is just, for me, is not adding value to the process. Nothing stop any senator from being Senate president for as long as first his people elect him or re-elect him and his colleague accept him. There is no shortcut to it. That is why I gave example of distinguished Senator David Mark. He held that office for 8 years. And all he needed to do to hold the office for 8 years was to earn and sustain and service the trust line between the Senate presidency and the distinguished senators.
Okay.
Oftentimes you will hear David Mark saying, the senators are my bosses because they elect me. Because the only right you have is the one your constituency conferred on you, namely to be a senator. To be a Senate president, you are first among equals. And you know, when we turn our back and allow small things to happen, that is how Africans produce dictators that become bigger than their own country. That was just my point, nothing personal about it. I mean, for example, I know that what has informed that rule is the most publicized fact that there are a couple of former senators, like Ideta said you have to. Perhaps the most compelling case, obvious case would be that of Senator Omoagege, who was a deputy Senate president. Now he comes back to the 11th Assembly, assuming he wins. And then you say it's no more ranking because it is not consecutively. Or Senator Okowa, who was a senator before going to become governor. Exactly the same way as distinguished Senate President Akpabio was senator, and then he lost election, he became a minister, and then came back to contest and become senator again. And he was considered as ranking. Now, this amendment says that once it is not consecutive, you are not ranking. You cannot even be, not just Senate president, you cannot even be a principal officer. How fair is that?
Very interesting point.
And that's quite a number. Nobody knows who is going to win the next election.
Absolutely.
I'm just saying that, you know, as a matter of morality, you don't make law either for yourself or make law against specific individuals that you fear will come. That is the beginning of the road to life, presidency, and dictatorship. That's why our neighbors can elect a 93-year-old man in Cameroon. And
very true.
it is a or 90-something years old man in, you know. That for me, those are the issues, nothing personal. Akpabio is my friend.
Okay.
But anybody who knows me knows that my friendship is important, but the country is much more important than my personal relationship with anyone.
Okay. Thank you so much, Senator Adams Oshiomhole, for speaking out on this. And I mean, you're not one to shy away from controversial, hot topics. But a few things. Number one, you say that it's not personal, but in your call, you actually made a call for a resignation of the Senate president based on this decision he's made. Do you still stand by that, or have you reconsidered that? That's number one. Number two, I hear you around not making laws that would, with one person in mind. And we did make that argument on this table when the news broke. However, there are other many areas that might be considered as such. For instance, a number of Nigerians criticized the way that the Senate handled the Electoral Act, for instance, and that certain provisions in the law sort of favored a particular party, a particular group, and that you didn't speak up against that. In the interest of democracy, some people might say that the reason why you're so passionate about this particular matter is because it affects you yourself, as you would not have spent 8 consecutive years, that if you're passionate about what is fair for Nigeria across board, then there were other matters in the Senate that you ought to have spoken up about aside from this particular matter. What would you say about that?
Now, I forgot now the first point you raised.
That's the Senate President's resignation of the Senate President that you called for.
No. I did not call for the Senate President's resignation. I said, and I repeated it here now, that is the inferences people drew from what I said. I said, if you make a rule and you insist that a presiding officer, such as the Senate President, must have 8 years consecutively back to back to be eligible to contest for the office of the Senate President, I say, sir, with due respect, now that you are presiding, you have not done 8 consecutive years. You have only done, under those rules strictly, you have only done less than 3 years. So if 8 years is a qualification, you have done only 3 years because by the same amendment, the previous 4 years are irrelevant. They are expunged by the fact that there was interruption. So you can't count them according to those rules. And so if you need 8 consecutive years to be a presiding officer, sir, you have not done 8 years. So why are you presiding? I mean, that is what I said. Now, of course, people can interpret it the way they want, but it's about common sense, it's about reason, it's about logic. Just to question the morality of saying the qualification I have to get a job, that if you have that qualification, you cannot get a job. Why? If his predecessors, the former Senate President Ahmed Lawal, under his leadership, they had changed those rules. Because Ahmed Lawal has been in the Senate for quite some time, and even in the House of Rep. He could have made those rules, but he didn't make them for him to become the president of the Senate. David Mark didn't make those rules to become the president of the Senate. What you need is to have the support and the buy-in of your colleague. Simple. So I didn't call for his resignation. But if the law says you must do 8 years, then obviously he hasn't done 8 years. And if it's a constitutional requirement, a legal requirement, it's about the law. You can't breach the law in perpetuity. if you bring the law in error, the courts are obliged to correct the error. That is the point. Now, as for the other issue about the Electoral Act, I think people look at just one item and they didn't look at the others. First, let me speak to the one that, although you didn't amplify, you just spoke in general terms about the Electoral Act. I think the one that people are worried about is about transmission of result to IRF real time. Now, real time, you check the definition. I think my dancing friend and colleague there,
Rufai
always talk about empirical evidence. Now, what is the definition by any dictionary of reference or Google of real time? It means immediately. Now, the truth of the matter is, intentions are good, but they are not enough. You must have an environment that will allow those intentions to flourish. As it stands today, there are occasions, even in areas where you have services, for some technical problem, you find that there's no service until they are rectified. And so, if you cast a vote and you finish and it is counted and they are recorded in the beavers, and you press to send and it doesn't go because there is no signal in that particular locality, and you have to move from there to the nearest area where you probably find signal, that is no longer real time. And if it is a law, lawyers and judges will have a field day, try to define and interpret the meaning of real time. And if they hold the view that real time means now, it doesn't mean 10 minutes away. It doesn't mean moving from one location to the other. Automatically, the entire electoral process in the country will be in jeopardy. That is the issue of that. But let me tell you, the issue should not amplify. We have now said before, if the electoral officer manipulates or beyond his control, you have a situation in which the beavers is not working, before you can use other means to accredit. If you've done everything and it's not working. Now, under the amended act, if anyone out of mischief or for really technical reasons, the beavers is not functioning, you cannot use incident form. What the law now say is that if it doesn't function that day, you will have to change the beavers. If you can't change it, the following day you must bring another beavers and the election continues before the votes will be declared. Read it. This is to make it mandatory to cure the mischief of people saying a beavers is not working or all the beavers simply failed and therefore we use incident forms and then throw out bogus figures. Even people who are there will come back to vote. Sir, you know, whatever you want to say, I fought against election rigging. I launched one man, one vote campaign as a city governor because I didn't want another Nigerian to go through what I went through in 2007 when PDP, under the policy of do or die, completely rigged me out. I have to go through the judicial process and evaluate. That was the era in which the late August Aikomu was alleged to have voted 4 times because his name was accredited. Now, those mischief has been cured by this amendment. There are a couple of other things that have been done. So, focusing on one thing is not fair enough.
Senator.
Yes, sir.
I mean, you see, I'm happy we have started on a good note. But you know, we'll normally have our fights, and we're never going to stop fighting because we are fighting for a better Nigeria. Senator, all these things you said, it's not that people are just talking. Your fellow Senator Ireti Kingibe alleged that the Electoral Act was altered behind the scene, claiming that the version signed into law is a fraudulent departure for what the stakeholders agreed upon. And I can go through a litany of many other issues because there's no time. Time will not permit us. Is it the issue of removing certificate forgery as a ground for election? Is it restricted judicial review, section 88? Is it elite capture in primaries that people are talking about? Is it financial barriers for grassroots? I mean, there are many issues like that. So we can go over all of them. But I want to ask you one critical question.
That is correct. With due respect, Rufai, you asked for empirical evidence. Read the section of the Electoral Act that say all of those things that you read out. Those are speculations. They are untruth. And the thinking can't proceed with that.
No, but what happened?
If you wanted to do that,
what happened to
just like I did on this issue? You should have rise up and speak to the.
Hang on a minute.
So-called doctor. How can anybody talk to Electoral Act?
Wait.
How?
Wait. What happened to Section 138? That removed presentation of forged certificate as a valid ground to challenge an election in the tribunal. What happened to that? What happened to Section 138?
No, let me hear you again.
Section 138 that removed
that says
presentation of forged certificate as a valid ground to challenge election results at the tribunal. What happened to that? What happened to that?
Okay.
Yeah.
Okay.
I still have another question. Let me add another question.
No, you can add. Let's take them one by one.
Let me add the second question because of time.
Igbo man say, hurry the tear trouser. So
no, it's not the tear trouser. Make I ask my question.
But if you insist, you can proceed.
Good. The second question I want to ask you is, in reacting to the issue in South Africa, you said they should nationalize MTN and DSTV. Is it that you forgot that they are Nigerian shareholders?
In fact, I remember there are even more that should be done.
Wait, is it that you forget that they are Nigerian shareholders in DSTV and MTN?
Yes.
So they should nationalize the shares owned by Nigerians there too, right? Is that what you are saying?
Can I answer?
Go ahead.
Can I answer you?
Yeah, go ahead.
Now, what I said is, I am aware that MTN is quoted. And therefore, Nigerian shareholders can hold on, but we take away the South African rights. And because of the issue, I'm not sure of the legal status, that's why I say you nationalize and then you reprivatize it so that Nigerians can take it over and the profit they are taking out of Nigeria will be retained here. There will be no South African share in it. The same goes for the other bank, RBCTH. There are quite a number of them like that. And Rufai, I am happy that after I made the point that the president of South Africa is a major shareholder in MTN. And as of the time I spoke, he has found it very convenient to keep quiet. I am also aware that during the campaign of President Ramaphosa for election to the office of president in South Africa, he made the issue that foreigners were doing the jobs of South Africans. Now the South Africans are hungry, there is no employment and so on, and they have transferred aggression against black people. So I said, when you hit Ramaphosa as president, you touch his economic interest in Nigeria, he will speak out. And call your colleagues in South Africa. Okay. They will tell you after they watch what I said on the floor of the Nigerian Senate. Thereafter, President Ramaphosa came out clearly to condemn the attack on black people. He didn't do so until I threatened his interest. But if you ask me, allow me, excuse me.
No, hang on, let me finish. When you asked, I beg you. But it's the same government that is saying they want investors. So how does that sound like when you can arbitrarily nationalize people's shares when they come to invest in your country and you want foreign direct investments? So if Nigerians have chaos with any citizen of any country, they nationalize their shares. That's how Adams Oshiomhole sees things, right? We just nationalize people's shares like that.
No. Now, what I want...
That's what you're saying.
Rufai, sorry, not Rufai. Rufai.
Go ahead.
You place more weight on wealth than the life of human beings. If anything leads to the death of Nigeria, what is the value of wealth to the dead? If it is your own value system, that investment is more important than the life of Nigerians that have been wasted and killed in South Africa, and the government is not on record as having convicted anybody to prison. And I know that those in government in South Africa are making money from Nigerian economy and cutting away that money to South Africa. Now, in my judgment, and this is a matter of value judgment, in my judgment, life is more important. We don't want investors who invest at the expense of human blood. If you need Nigerian blood to service and you do not care about Nigerian human blood because you want to attract investors, I will say, even in my poverty, I value my life.
Okay.
If in your own case you value
Mr. Oshiomhole.
investment, etc.
Mr. Oshiomhole.
But you are wrong. You are
Mr.
wrong to
Oshiomhole.
say if we wait. No. Yes.
Mr. Oshiomhole, why don't we nationalize the
Yes,
wealth
Mr.
of
Rufai.
all Nigerians rich men because people are dying in the north?
Okay.
How does that argument sound? Why don't we nationalize the wealth of all Nigerian rich men because people are dying in the north and we've not been able to solve insecurity?
Senator,
Let's start by that.
Before we go.
All right. Rufai.
Senator,
Rufai,
please, let me ask you this question.
Rufai, that's your problem.
About nationalization, even Stammer.
No, you can't ask 4 questions with the answer. No, you are not talking to a deaf man. You have 3 questions you have not allowed me to answer.
Okay, go ahead, please.
You have obligation
Senator
to
Adams,
listen to
go
the
ahead,
person
please.
you have dragged out to
Yes,
come and
please.
question.
Senator Adams,
Now,
please go ahead.
Rufai, this is to you. Rufai, this is to you.
Yes.
This is to you.
Yes.
Please go ahead and nationalize. That is not my problem. I do not belong to the excessive free market people. But you are comparing like with your like. But I ask you the question, Rufai, is human economy worth or foreign investor, foreign dollar more important than the life of a Nigerian? Answer the question. When the countries, for the first time, they kill Nigerians, they got away with it. Second time, they riot, they kill Nigerians, they got away with it. Third time, they kill Nigerians, they got away with it. Under Buhari, there was an agreement. They broke it, they are killing Nigeria. Nobody is in prison for murder, extrajudicial murder. You are talking about law. Is there no law protecting the life of foreigners who live in your country? Even if they were there illegally, there are legal ways to repatriate them, to deport them. Excuse me, what is money to the dead? If you are a slave of wealth, if you are a slave of foreign investor, even if that investor is blood-soaked and he feeds on Nigerian blood, and you are happy with that because you want the dollar by all means, Rufai, you and I, we do not belong to the same school, and we do not share the same value system. Money is not everything for me. Whatever you want to, if you want to trivialize it and compare like with your like, compare banana with oranges, it's your choice. But I am clear, Nigerians know where I stand. And I'm happy that Nigerians in South Africa, they are happy that somebody spoke for them. And even the South African president, after I spoke, and I accused him of doing nothing, and that he will go on his knees to beg, when we hit him, he has made a broadcast condemning the attack, right, which he didn't do before I said it.
All
so
right, Senator,
I have no regret whatsoever.
All right, Senator, thank you so much for your time with us.
Hold on. Senator, no. Senator, I wanted to ask you, this talk about nationalization is immaterial because even in the UK, Starmer is talking about nationalizing. Let me ask you about politics.
All right, let me put it clear.
Okay.
What
we have to go. I'm so sorry, sir. We're out of time.
It's not just Senator, to nationalize.
Thank you so much.
When
Senator
you take
Adams,
it out from there, you
Senator
sell it and privatize.
Thank you so very much for your time with us today.
We
are so sorry for the time that has been taken. So sorry about that.